Hello, are you ready to take your exam? Anyway, I was having a little bit of technical difficulty. My Kindle app wouldn't open, so I'm still having a little bit of challenges, so please bear with me. We're going to continue with national questions and answers, and then at the end, we're going to do Texas state questions. However, my Kindle app was struggling, so bear with me as I get all this squared away for a moment here. 47. Because when we don't want things to go wrong, they have a tendency to go wrong. And so today we're starting out, today we're continuing with national questions dealing with land use, legal description, and contract law. And so let me share. Okay, so this is the book that we're using, and we'll continue to use this throughout all the sessions that we do. And so today we're at, test number 3, number 6. Yes. Okay. So thank you for your patience as I was getting this. I had to restart the computer to make sure that had this working. And okay, here we go. So again, I'm going to ask you to please participate. Those of you that are here, remember to type the question number and the letter answer, and let's do this together, okay? Because I want you to pass your exam, so study every day. Okay, so number 6. How does planned unit development zoning vary from ordinary zoning? Okay, maybe I should put this on the bottom. Yeah, that'll be better. So A, it applies only to office parks. Pay attention to those little words: only, must, never. B, it incorporates a number of different zones with a single property boundary. C, it requires that multiple tracts of land be developed according to a single design. Or D, it requires developers to obtain a separate building permit for every structure. So again, how does planned unit development, which abbreviates to PUD, okay, PUD, P-U-D, zoning vary from ordinary zoning? So is it A, B, or C? It applies only to office parks. Or B, it incorporates a number of different zones with single property boundary. C, it requires that multiple tracts of land be developed according to a single design. Or D, it requires developers to obtain a separate building permit for every structure. Well, it's not A. Okay, so I'll give you that much. And I'll type the answer in the chat. I'll give you a moment to do this. So the answer here is 3.6C. It requires that multiple tracts of land be developed according to a single design. So you'll see like different areas, sometimes mobile home parks or retirement communities, that have plant unit development and other areas within the city, but it is multiple tracts of land. Okay, so different lots, different acreages be developed according to one single design. 3.6, oops, I was writing the letter again. C. Okay, can everybody hear me okay? Hopefully, yes. All right, number 7. Oh, let me enlarge this here. Number 7. Which of the following situations is most likely to represent an illegal non-conforming use? So what is a non-conforming use? That's a vocabulary. A homeowner is a residential zone converts a residence to a private school. B, a homeowner builds a tool shed in a neighborhood where there are no tool sheds. C, a store owner remodels the storefront in accordance with regulations, and then the zoning is changed to residential. D, a new zoning ordinance outlaws the two-story additions after a home completes an addition. So which situation is most likely represent an illegal non-conforming use? In other words, it doesn't conform to everything in the area that meets zoning. So what is the answer for 3.7? The answer here is 3.7A. A homeowner in a residential zone converts her residence to a private school. That is illegal non-conforming. In order to change a residence to a private school, they have to go through the variance board and zoning and get approval. In order to get approval, the zoning board or the adjustment board will send out notices to all the neighbors to see if it will, negatively impact them, and they don't want that. So they can't go ahead and just illegally do it. So let's see what the answer here says. So it says a legal non-conforming can be illustrated as follows. A motel is situated in a residential area that no longer allows commercial activity. The zoning board rules that the motel may continue to operate until it is sold. So that is something that would be called grandfathered in. Once it's destroyed or used for any other commercial purposes, okay, they cannot use it as the motel. An illegal, which in this case, non-conforming use is one that conflicts with ordinances that were in place before the use commenced, before the use started, okay, commenced. For instance, if the motel in the previous example is sold and the new owner continues to operate the property as a motel, the motel is now illegal, non-conforming use. So in order to be conforming, they have to go, as it says, through an adjustment board, through the zoning. You can't just do whatever we want with our land. Out in the county where there are less restrictions, maybe, but not within the city. So converting the home to a school is non-conforming and it is illegal. Number 8. What is the difference between a variance and a non-conforming use? What's a variance? What's non-conforming? Two vocabularies. A variance once granted and is unconditional and permanent. So a variance once granted, once they're given permission by the adjustment board, is unconditional and permanent. B, a variance is granted by the zoning board if the owner has a justifiable reason. C, a non-conforming use is allowed if the owner requests it in advance of building. Or D, a non-conforming use violates current zoning but a variance does not. Okay, so what's the difference between a variance and non-conforming use? So a variance, they're going and requesting a change. Non-conforming means it's not equal or appear to all the others in the area. However, they were maybe given permission to continue using it, like when a motel was existing in a commercial area, but the zoning changed to residential. Well, that is non-conforming use and it's grandfathered in until it's sold or it burns down. So on 3.8, the answer is, I know that's a long explanation, B, a variance is granted by the zoning board if the owner has a justifiable reason. So let's say they want to add another garage on their lot, and the zoning says only one garage, and this one will be detached. Well, they can go to the zoning board and request, hey, I would like to apply to have an additional detached garage. The zoning board will then send out a letter to the community within a certain radius, and then they have an adjustment board meeting, and the public can come and the person that requested it. If there is no one against it, then the board, if it meets their requirements, will then approve it. If somebody is against it, then the board may reject it. Okay, so that's what a variance, it goes through a process. Non-conforming becomes automatic. So a commercial area became residential, but there were businesses there. So those businesses continue to exist, but they're not conforming to now being residential. So they are considered grandfathered in. So the answer here says, a non-conforming use is one that clearly differs from current zoning. Okay, so if zoning changed, what was before gets to stay there and is subject to change upon conveyance. Well, conveyance means when they sell it. Once it transfers to another owner, then it has to abide by the new zoning. A zoning variance allows the use that differs from applicable ordinance for a variety of justifiable reasons. Okay, so variance is to make a change currently on your property, and it has to be approved. Non-conforming is a change that happens because the zoning changed, but the businesses or homes, let's say there was a home on a residential area and it changed to commercial. Well, that home gets to stay there, and it's considered non-conforming to the new zoning, and it is grandfathered in. However, that house burns down or they sell it, then it has to become commercial. So let's say they sell the home and the home stays there. So whoever buys it has to use it as a commercial business, an office or things like that. A lot of times residential areas in certain busy streets become commercial or semi-commercial. Oh, let me type the answer. So 3.8 was B. Okay, so there's several on here. I'm inviting you again to participate. Number 9, a document certifying that structure complies with building codes and is ready for use is referred to as A or an A, inspection report, B, satisfaction bond, C, certificate of occupancy, or D, user permit. Okay, so it says a document certifying that a structure, so something that was built, complies with current building codes and is ready to be used. What do you think that is? So something new that was built, never been used, now it meets all the building codes after all the inspections, and it's ready to be occupied. Well, I gave you a clue word there. Anybody? Come on, give it a try. The answer here is 3.9C. They get a certificate of occupancy. That is when it's new construction, never been occupied before. It was built, goes through all the zoning. They get the zoning permit before they start construction. During the construction, they have to go through different inspection stages. So the city inspector comes and checks the foundation when the plumbing was done, the electric, then the foundation concrete, if it's on concrete foundation, then the electrical, the building structure, they go and inspect all that. Once they pass everything, then they're given the certificate of occupancy after it's completely built. Okay. A lot about real estate that you're going to experience and learn. Some of it you may use, some you may not. And that particular applies to residential and commercial. All right, number 10. Let me see if I can make it a little bit larger. There we go. Number 10. Which of the following is true of an eminent domain proceeding? What is eminent domain? A, it canceled the property's owner mortgage loan balance. B, it leaves the property owner with equitable title in place of legal title. C, it conveys legal title to the acquiring entity. Or D, it clouds the chain of title by canceling the original grant. It has nothing to do with a loan. So I'll give you that one clue. So it is not A. So it can be B, C, or D. Nobody. Okay. The answer here to 310 is C. It conveys legal title to the acquiring entity. So in eminent domain, that takes property for public use from an owner. They have to pay, the market price, which sometimes the owners may not agree that that's the market value of their property. However, the government takes over the property. A portion of the property is then granted to the government through eminent domain proceedings. And the title, the legal title of that particular portion of the property, it conveys to the acquiring entity, being the city, the county, the government, whoever's taking over it. But it is done for public use. So if you're not familiar with eminent domain, do vocabulary. So there's condemnation when the eminent domain, the city condemns a property because, hey, now I want a portion of your property. Let's say they're building a wider street, an expressway, and they need the land, or irrigation, and they need part of that land to help with the irrigation, which is going to help the community. So they condemn it until it goes through the whole process of taking over the property, providing the owner with a current market value for that portion of land that they are going to get. And they, meaning the city, the government. Come on. Get with it here. Number 11. Any questions? Oh, let's see. We have a question here by MJ Smith. It says, do you have a prep course for the National Real Estate Exam? we are doing right now national real estate questions. So these are for the national exam. I don't have what you call a separate course where I just do national. I go live, MJ Smith 260. I go live and I've been doing this for years. If you want to purchase a prep course, I recommend someone like a Prep Agent with Joe Juder. And he's together with, Aceable, and he sells prep courses. Or other schools, or I would say buy the book, the prep book, okay, that I use here. It's an excellent book to help you prepare for the exam. Okay, this book is a prep book. So if you a lot of times you'll learn more from the prep book than sometimes from the prep course. It depends on how you learn. Do you like to learn a bit through a book, or do you need to go in person? So some people learn audible, others visual, others and instructions. Okay. So no, I do not do an immediate prep course. Maybe I should do that, but I think I need to go through a certificate class. All right, where were we? Number 11, but thank you for asking. You can find different prep courses at different prices. If you go in person, it's more expensive because you've got a teacher in a classroom, you're paying for the building, for the school and all that. If you do it online, it is cheaper. If you do it through somebody like a Prep Agent and Aceable Agent, they're together, collaborators, then it's also less expensive and you sometimes get to repeat it. But I highly recommend a prep book, unless you definitely need to go to a class or a course. You can do it at a university also. A lot of universities now have real estate courses and actually real estate degrees. Not when I started. Okay, come on, number 11, show up completely. Dang it. Keeps getting smaller. Sometimes this is a little frustrating, so just bear with me. It's because I'm using the Kindle app and I have to do it this way versus creating questions and doing one at a time. This way it helps you buy the book and follow along. All right, number 11, among other provisions, oops, uh-oh. Okay, we're back. Sorry, I banged my computer. Among other provisions, the Superfund Act, referred to as CERCLA, and Superfund Amendment and Reauthorization Act of 1986 provided that a large development project undergo an environmental impact survey immediately after completion of construction. B, industrial users of real estate comply with air quality standards. C, the EPA would give financial help to homeowners to remedy any hazardous situation resulting from radon, asbestos, or lead-based paint. D, parties responsible for improper disposal of hazardous waste could be charged for the cleanup costs. So what is CERCLA? I'm going to pull it up here so that you can see. So know your acronyms. And, study those acronyms so you know what they are. And I'm going to share. So what I do is I Google it. Okay. So CERCLA Comprehensive Environmental Response, Compensation, and Liability Act. That's what CERCLA stands for. Known as Superfund, is a federal law authorizing the EPA to clean up uncontrolled or abandoned. Let me see, can I enlarge this here? Because it's kind of small. Okay, that's better. So it's a federal law authorizing the EPA to clean up, control, or abandon hazardous waste sites, accidents, and spills. It imposes liability on responsible parties for cleanup costs and establish a trust fund funded by industry taxes for sites where no responsible party is found. So that is CERCLA. And the Superfund amendment and reauthorization, okay, of the only problem here, I can't get it back when I remove it. Let's see here. Okay, there. And so what was it? The Superfund Act? What was it? Superfund amendment. So when in doubt, hey, just Google it. Okay, don't hesitate to Google things instead of going to search it on your books. Now you have to confirm to make sure that it's correct. So the Superfund Amendments and Reauthorization Act, enacted in 1986, amended the comprehensive CERCLA, okay, the Comprehensive Environment Response, Compensation, and Liability Act, to enhance hazardous waste site cleanups, increase funding to $8.5 billion, and stress permanent innovative treatment solutions. So now that we reviewed that, which answer do you think is correct for 311? Among other provisions, the Superfund Act, CERCLA, and Superfund Amendment and Reauthorization Act of 1986 provided that A, B, C, or D. So I'll just tell you the answer. Okay. The answer here for 11 is D. Parties responsible for improper disposal of hazardous waste could be charged for the cleanup costs. Sometimes old gas stations used to have huge gasoline containers underground. And if that's ever sold, they have to dig all that out and clean it up. So the answer here was D. So the Superfund and the amendment provide for parties responsible for improper disposal of hazardous waste could be charged for the cleanup costs. So again, it's protecting the community, the environment, right? For the public. And that's why Texas state laws and every state, their laws keep changing, right? Because there's new things that are added. Oh, pardon me here. See how easy it is to go on Google and find answers? I love it. It's so convenient. And there's another website, more explanation. Okay, number 12, and that's Perplexity. In case you want to look it up, Perplexity. It's online, or you can download the app Perplexity. It's more advanced than Google and gives you more explanation. All right, number 12. Public land use planning strives to balance which of the following potentially conflicting interests? Public land use planning. So every city has planning zoning departments, right? Strives to balance which of the following potentially conflicting interests? A, individual property rights and the public's interest. B, public policy makers and community business leaders. C, tenant occupancy specifications and construction contractors. Or D, individual property owners and municipal planning agencies. So public land use planning strives to balance which of the following potentially conflicting interests? C, MJ, tenant occupancy specifications. Well, tenants are having to rent what's already existing, right? So it has to do with A, the answer is A, individual property rights and the public interest. So individuals have property rights on their land, but it also has to make sure that there aren't any conflicts that impact the interest of the public to use land. Okay, like parks, streets, that type of sidewalks, that type of thing. So the answer, let me type the answer first. 312 is A. So it says public land use. Okay, public land use. So tenant occupancy doesn't deal with, they're using rental property, but it's not for public use. Okay, so public use planning strives to balance which of the following potentially conflicting interests: property rights and public interest. That's where zoning comes in really strong. But thank you so much for participating. So it says here, the optimum management of real property usage must take into account both the interest of the individual and the interest of surrounding community. While maintaining the value of an individual estate is important, the owner of the estate must realize that unregulated use and developments can jeopardize the value not only of the owner's estate, but of the neighbor's property. So that's where zoning develops rules for different areas within the city. The city has high, strict zoning rules for single homes, so smaller lots, and then for duplexes, fourplexes. After fourplexes, it becomes commercial, okay? Because anything from 1 to 4, as you see on your contract, 1 to 4 residential contracts, right? That's considered residential. So if you have a fourplex, it's residential. Once you have more than a fourplex, then it becomes commercial. So property owners have to make sure that they're not conflicting with the, public parks, other in areas, other communities, commercial. It all has to blend in and work together. So people get fined if they violate. All right, number 13, because we're dealing here on this section with land use, legal descriptions, and contract law in this national question. So anybody who came on right now, we're dealing with national questions. Number 13, zoning, building codes, and environmental. Well, let me see if I can make it a little bit larger for those that also see it on the phone. Sometimes it doesn't work conveniently with me. Oh, well, I'll leave it there. Zoning, building codes, and then, number 13, right? Oh, gosh, you already answered number 13. Zoning, building codes, and environmental restrictions or forms of local land use control known as A, master planning, B, preemption, C, police power, or D, concurrency. And yes, you are correct, MJ Smith. It is police power. 313C is police power. So that zoning, building codes, environmental restrictions fall under police power. Very good. Thank you for participating. I love it. exerts its power of eminent domain against a certain property owner, what happens? A, the owner must pay higher property taxes or give up the property. B, the owner must cede an easement without receiving any compensation. C, the municipality annexes the property. Or D, the owner must sell the property in exchange for market value compensation. Okay, pay attention to the keywords must, must, must. Sometimes that can lead you to the wrong answer, and sometimes it is the right answer. In this case, one of the must is correct. And MJ Smith, sorry, you are correct. The answer for 314 is D. The owner must sell, it's a must, the property in exchange for market value compensation. So that is eminent domain, where the land is taken for public use. And the owner doesn't have a lot of choice unless they want to go to a big legal battle. And a lot of times that'll end up costing more. So it depends on what the city is taking the land for, what kind of use, right? And the owner can do inverse condemnation, mean they can fight for the property value, and eventually they'll come to an agreement. Number 15. Excuse me, I need to take a little bit of sip of water here, take a moisten. Gee, Lily, quit dripping all over. Okay. And thank you for participating. I love that. And it's here to help you. Trying to make it, no, that didn't work. Let's see here, take 15. Okay, number 15. To be valid, a local zoning ordinance must, okay, this is a must, so one of the answers is A, reasonably promote community health, safety, and welfare. B, comply with federal zoning laws. C, apply only to unique properties. Or D, published periodically in the local newspaper. Well, not a lot of newspaper reading nowadays. So to be valid, a local zoning must do what? It's for safety, right? What did the prior question say? Oh, no, I'm sorry. So the answer is A, to reasonably promote community health, safety, and welfare. That's why there is zoning. But thank you for, oh, great. You changed your answer. That's awesome. Sometimes when we change the answer, we get it wrong. But in this case, you got it absolutely correct, MJ Smith. So sometimes you've got to go with your instinct and your intuition. However, read carefully the question. Sometimes read the question completely. Here, valid. Local ordinance must. Zoning is a state issue, not federal. Correct. And it's actually also city. Every city has their zoning. Because you've got to go to the city, okay, or the city planning, and in order to build, right? So yes, local zoning. Very good. Thank you for that. So this is what MJ said. Zoning is state issue, not federal. It's not federal. It's city. It's local zoning. There are some state laws and things like that when they start to create other things to help with the growth. The state gets involved and provides money for certain expansions around the community. So the city will need support, and they get it from the state. Something that's federal is like the lead-based paint disclosure. That's federal. It's the same for all 50 states. Number 16. Why do communities require building permits? Excellent question. A, to promote development. B, to establish the basis for an inspection. C, promote certificates of occupancy. Or D, to ensure that improvements comply with codes. So what do you think? Come on, participate. I've got 3 individuals right now. Anyone? The answer is D. To promote, to ensure that improvements comply with codes. MJ, thank you for trying. But so why do communities require building permits? It's not for promoting certificates of occupancy. That's a must. The city will provide a certificate for occupancy on new construction. However, how about existing construction, where people want to change and do whatever they want on their property because they say, well, it's my land, it's my home, I can do what I want. And unfortunately, we never own something 100%, right? We've got to pay taxes, and we've got to follow rules and zoning codes. And as issues come up with health, then the zoning codes can become stricter and require owners to, if a home is sold, that the new owner has to abide, by the new zoning codes. All right, so that was 316. Okay, so which section in the so here's a question here. Which section is this in the real estate exam? Property ownership? No, this section has to do with legal descriptions, land use, and contract law for national. Okay, so let me show you. Oops. So test number 3 on this book. Land use, legal description, and contract law. Okay, property ownership has to do with what types of property ownership can you have? And let's see. Okay, that was in this section: rights, interest, and estates, and ownership. So you have 4 different types of property ownership, right? We're on land use. So that's the answer to it. I got 4 out of 5 on land use. Oh, okay. So you took your exam already, and you got 4 out of 5 of them correct, or you're talking about right now? Oops. So go back. There. You got 4 out of 5. Oh, on the exam. Okay, so you took the exam at least once already. Okay. And what state are you in? Are you in Texas, or what state, since we're doing national questions? So that's good. We have someone that's been taking the exam. That's MJ. Contract agency and real estate math I need help with. Okay, yes. Contracts is a lot. And the principles of agency, there's so much to know. So I have a lot of videos where I go through all the questions, okay? And I think it would be better when you're following a prep book like the one that I use here, to Okay, I want to just study this particular section. You're in North Dakota. Oh my gosh, it's got to be really cold, but we'll apply for the reciprocity for Texas. Ooh, Texas doesn't do reciprocity with any state. So you're going to have to get a Texas license because you're moving to. So MJ Smith is in North Dakota, and he's moving to Austin, Texas when I get licensed. Okay, Texas, unless it recently changed, I haven't checked, does not have reciprocity with any state. So let's see here if that's changed. I haven't looked it up. Does Texas real estate license have reciprocity? No, Texas does not have full real estate license reciprocity, meaning you cannot simply transfer a license from another state. You must meet Texas requirements, including education and state exam, though you might be exempt from the national portion. So MJ, when you pass the national and you get your license in North Dakota, you don't have to take the national exam again. However, when you move to Texas, just like I did, you'll have to take the national, you'll have to take all the courses again in Texas, only take the Texas exam. Excellent question. Yeah, oh darn is right. When I moved here from Oregon, I had to do the same thing. I had to take the Texas state exam. Okay, so where did we leave off? 3 feet. Okay, so I think we're going to move now to Texas state questions. So you're in that. Well, since you're here and you're in national, you're participating. I'm going to do some more national questions. Okay, does that sound good? So we are next with number 17. Thank you for sharing with that. So, hey, you could always go back and practice real estate in North Dakota and then also in Texas. I used to have Oregon and Texas license. I gave up my Oregon license after a few years. Okay, number 17. What is the purpose of residential zoning? So, new comment. Education requirements for renewal is different. Every state has different requirements, okay, for renewal. In Texas, renewal of a license after 2 years, okay, is 18 hours. However, when you first get your license in Texas, you've got to do 90 hours. In addition to the 180 hours for the 6 courses in Texas, then you take 90 hours within the first 2 years. I did it by taking 3 courses of 30 hours apiece. So I got them done quickly. Thereafter, every 2-year renewal is 18 credit hours in Texas. I'm not sure about all the other states. Okay. Yes. All right. So, hey, get your Dakota license and then get your Texas license, and you can practice on each, but you'll have to get your renewal in both states. Number 17. What is the purpose of residential zoning? A, to increase home values in a neighborhood. B, to regulate the density of dwellings in the residential zone. C, to prevent families from residing in commercial and industrial sites. Or D, to maximize intensity of usage. You are correct, MJ. It is 317B. To regulate the density of dwellings in residential zone. Very good. Thank you. Number 18. Okay, now I ask everybody else to participate. Come on, you'll have fun. We have fun together. I also learn it even better. Because if I have to explain it and I'm not sure, I'll Google it, just like I was showing you. Okay, number 18. A nonprofit organization wants to erect an urgent care facility in a residential zone. Given other factors of favorable circumstances, the local authorities may grant permission by allowing what? A special exception, B, an illegal nonconforming use, an easement, C, or D, a license. Well, it won't be illegal nonconforming use, right? Because it's here. The local authorities may grant permission. So they're not going to grant permission for illegal. So immediately get rid of that one. No, it is not an easement. Okay, it is a special exception. 318 is a special exception. No, it's not D, it's not a license. When you're dealing with zoning, it's not a license, it's a permit, and you can get a special exception. And like churches can build. So 318 is A. Oh, darn. Yeah, I agree. So maybe from now on, I should show the answer, but I need to change the label. Too much stuff on there. So it is a special exception because there are a lot of urgent care facilities around the city and around communities, and it can be close to commercial, residential, right? Because as the population is growing and they're needing more doctors, that's why now we have a lot of urgent care to make it a lot quicker and easier instead of having to go to a hospital. So you got that one wrong on the exam. Oh, you remember a lot of these things. That's awesome. All right, 318 was D. It's a special exemption to grant the zoning grant permission for a nonprofit organization to have an urgent care facility in a residential zone. It was a variance, non-conforming use, or easement. That's the difference. Yeah, so this is kind of like a variance. It's not an easement. An easement is like the utilities. Okay, if you have utilities going through your property, that's one of the police powers. They're going to have an easement right of way to go repair power, water, sewer, okay, that type of thing. That's an easement. If someone shares a road with a neighboring property, then they'll record an easement. So two properties have one driveway. And that can happen in, a lot of times it happens out in the county, but sometimes in the city when there's a flag zone type of a piece of land. And so an easement, then that you have like a grantor and a grantee, you have the dominant and the servient party. So the dominant is the one that gets to use the easement. The servient is the one that owns the easement. Someone could also have an easement for sharing a well, sharing a septic, sharing a road. Those are easements. And in order for it to pass with the land, it must move with the land. It must be recorded. Yes, an easement appurtenant, right? But in this case, this is not an easement, okay? They're not being granted the use of a piece of land shared by somebody else. So they have their own piece of land and they want to erect, a nonprofit organization wants to erect an urgent care facility in a residential zone. So they have to be given permission, okay, by the zoning board or the planning committee, and that's a special exception. So then here, what situations which required a license instead of an easement appurtenant? Let's see, waterway use of the right to use of water, but it's not a license. The planning departments and zoning, they don't necessarily give licenses. They give easements, right of way use, or variances, or you have non-conforming property when zoning changes. Eastman and Gross is the utility company, right? Well, let's confirm that, because there's a lot of very good questions. So let's look that up real quick. Eastman and Gross. Sometimes, so it's illegal. So an easement and Gross is a legal right allowing an in for specific purpose without owning it. So utility companies or a dominant estate. So typically used for utility infrastructures, okay, pipelines, power lines, cables, conservation, or personal access, like for fishing, hunting license. Oh, you might get a fishing license, hunting license, but that's from what? The Fishing and Animal Hunting License Board. Okay, so yes, so Eastman and Gross is like all the utilities. Okay, key aspects. So typically it's like fishing, hunting. Parties involved, it involves only one party, the servient party. That's the one that owns the land, the servant estate that is burdened by the right. So remember, you have a servient party and you have the dominant parties. So the dominant party would be the utility companies, right? The government, the police power. Transferability. Commercial easements, utility companies are generally transferable, while personal easements are usually non-transferable. So the personal easements, so those go with the land if they're recorded. Okay, but all those utilities, those are permanent. They stay there. So it doesn't necessarily transfer from a person to another. It belongs to the police power. And then termination. These easements can terminate when the holder dies, the purpose no longer exists, or through written release by the holder. Well, not the police powers. The termination of easements could be like the well, the septic. However, if it's recorded, it doesn't die. It goes with the land. It moves with the land. Okay, if it was a temporary private easement that was given to one person, hey, you can come and fish off my land, but I'm just giving you the right of way while I'm here. That person dies, that easement is gone, because that's a temporary. So other examples of easement and Gross: utility lines, conservation easements, pipeline right of way, personal use, a neighbor being granted personal, not transferable permission to access a private lake or fishing, just as I mentioned. Okay, very good question. Thank you, MJ. See, I'm going to have some of these lives where I'm going to have you just ask questions in general. Okay, I don't know them, I Google them so that you know how to search for them. Okay, we just did question 18. I love it. Thank you so much, MJ. Yes, we did 18. So we're going to do now 19. And I hope this is helping everybody else. And when you rewatch the video, play it at a faster speed. If you understand my articulation of words, you can play it at 1.5 or even 2.0. You don't have to play it at the slow speed. Number 19, a property that conformed with zoning ordinances when it was developed, but does not conform to new ordinances is said to be what? A, an illegal special exception, B, a variance, C, a legal non-conforming use, or D, unmarketable? I'll get back to your other question in a moment, okay? MJ. Oops, sorry. So what is the answer to number 19? We've been talking about all these zoning uses, right? If something changes, no, it's not B, sorry. It's non-conforming use. So it says a property that conformed with zoning ordinance when it was developed, but does not conform to new ordinances is said to be. So let's say it went from residential to commercial or commercial to residential. The existing owner gets to kill it or it burns down. It has to abide by the new zoning codes, new zone codes, new ordinances. So 319, the answer is C. That's in Charlie, a legal non-conforming use. Okay, let's go back. You had a question here. Septic tank question. I got wrong with the EPA. Oh, okay. Yeah, septic tanks are in rural properties. And it depends on what the question was with the EPA. That they have to abide by Environmental Protection Agency rules and not to contaminate the water and not be close to a well or other water usage. They have to be far away from that. Number 20. The approval process for development of multiple properties in an area includes submission of A, covenant of restriction, B, a plat of subdivision, C, a court order, or D, a developer's pro forma. So you've got a development, a piece of land, and now it's being subdivided. So what do you think you need? To have multiple properties in an area include submission of in a development, right? Yes. The answer is B, a plat of subdivision. Does everybody know what a plat is? A plat of subdivision. Let's see here. Let me show you an example. Subdivision plat map. Oops. So here, this is a subdivision plat map that has to be approved by the city zoning. That's it. But the picture, it won't let me show you. Oh, here. So these here are subdivision plats. Okay. So it's a large piece of land that was subdivided into multiple pieces, and each one becomes a residential property. So this is residential development, subdivision, and that developer may have additional control. Okay, so let's go back. Okay, so that's the end of national questions. We will now do a few Texas questions. Oh, the septic question had to do with land use control. Yes, okay. Okay, so now we're going to go into Texas questions. I mean, if you have to eventually take the Texas exam, you could continue staying on here. So let me transition on my Kindle book. so that we can then do some Texas questions while I transition. Any other questions? Thank you so much, MJ. That's been excellent. So, Texas questions. All right. Uh, 592. Okay, we'll start with 1610. What days do you go live? I've started going live Tuesday, Wednesday, and Thursday. This is what I used to do about a year and a half ago. I would go live 3 to 4 times a week to help you prepare for your exam. So I've started that again. I took some time off to focus 100% on real estate, and I wish I got more sales and I did one, but focusing just on real estate. However, I missed doing these classes. So 6 p.m. Central Standard Time. I forget, is Dakota Central or Mountain? So my classes are 6 p.m. Central Standard Time. Okay, number 10. Again, here we start with Texas questions. So put your Texas thinking cap on. And we're starting with number 10. And we're dealing, this test has to do with Texas contracts and special topics. Which of the following is not, okay, oops, sorry. Let me share the screen. The screen, no, it's the screen. Yes, MJ. So I'll be here again tomorrow, Thursday. Okay, you can see the screen? Yes. All right. Which of the following is not a landlord justification for keeping a tenant's security deposit? I thought I did that one yesterday. A, to eliminate normal wear and tear. I did do that one yesterday. To the apartment, including painting and carpet cleaning. B, to offset rent owed by the vacating tenant. C, to repair damage to the plumbing system. Or D, to cover excessive damage caused by a dog, even though dogs are permitted. So to eliminate, which one is not a landlord use of the security deposit of a tenant? And remember to always read the questions carefully. So yeah, this one was on yesterday's class. Actually not, MJ. The answer is A. So a business owner, an investor, cannot keep money for normal wear and tear. That's part of their investment, to upkeep a property and to then rent it. They're making money from the rental, so they are able to then maintain the property so it's habitable for someone else to rent. So I used to replace flooring, paint them, depending on what it needed, anytime a new tenant came. Or anytime a tenant left, I would update it and make it look fresh and new, because I've been an investor. So it is to eliminate normal wear and tear to the apartment. They cannot keep a tenant's security deposit for that. They could offset rent owed by a vacating tenant. They could repair damage to plumbing systems caused by the tenant, or to cover excessive damage caused by a dog, even though dogs are permitted. Okay? So number 11. Oh. Okay, get why that's the correct answer? In maintaining proper relations with tenants, landlords and tenants are obligated to meet certain apartment security standards. Which of the following accurately identifies one such standard? A, tenants may alter security devices, but at their own expense. B, landlords must install window locks in occupied buildings. Tenants must install security bars for glass doors. C, all security devices must be repaired within a 30-day time frame following tenant's written notice of the despair. Or D, the landlord must rekey the locks within 7 days following a tenant's vacating. So, in proper relations to tenants, maintaining, landlords and tenants are obligated to meet apartment security standard. Which of the following accurately identifies one such standard? No, it's not B. Landlords must install window locks in occupied buildings. No, they don't have to have window locks. And tenants to install security bars? No, that's major expense to install security bars. The answer is D. The landlord must rekey the locks within 7 days following a tenant's vacating. Why? Because if that tenant has a key, didn't turn them all in, they could go back into that apartment and get in when there's a new tenant. So a landlord has to change. They can rekey them. They don't have to change completely. Okay, like it says there, rekey, change completely all the doorknob, but they do have to rekey them. So the answer to number 11 is D as in dog, rekey them. And the tenant can't do anything without the consent of the landlord. All right, number 12. Let's see if there. Okay, so that sounds like a Texas state question. Yeah, these are Texas questions. So you retake your exam March 7th. Oh, why are you waiting so long, MJ? While your information is fresh and you just took the exam, I would recommend you take it again pretty quick after you taken one. Why? Because the information is fresh on your mind, like you're remembering some of the questions that you missed. It's better to do it soon after and not wait a long time. Number 12. Texas, well, that's my thinking, okay? Texas Property Code Chapter 92 is very specific about fire safety regulations. According to code, A, there must be a smoke alarm on at least the ground level of two-story duplex. B, fire alarms must be inspected annually by the landlord. C, tenants are responsible for inspecting and repairing fire extinguishers. Or D, there must be a smoke alarm in every bedroom of a dwelling unit. So Texas Property Code is very specific about fire safety regulations. So what do you think the answer here is? And these codes get stricter and stricter as accidents or injuries or life disasters happen. And it's what? Public safety, right? Yes, the answer is D, MJ. There must be a smoke alarm in every bedroom of a dwelling unit. No, you were right. You had D. The answer is D. There must be a smoke alarm in every bedroom. You were right. Don't change your answer. So you changed it to B. A fire alarm must be inspected annually by the landlord. No. Fire alarms can be, not all have fire alarms. Okay. Commercial buildings maybe, but residential homes may not have fire alarms. By you participating, MJ, it makes my doing this more enjoyable. I can't change my answers. That's how I failed last time. Yes, y'all listen to that or y'all see that? I can't change my answers. That's how I failed last time. The only time I would say change an answer is if a future question triggers you to realize that the prior question, you answered it wrong. I have had that happen, and that can happen. In that case, yes, I would say go and change it. Because sometimes you get multiple questions of the same topic, and they're just worded differently, or they change the answer some, then you can go back and change that one. But if you're guessing, then I would say stick to your first one like you did here. 612 was D. Okay, number 13. Utility service to tenants is regulated by Property Code 92. One of these regulations is that A, tenants are responsible for all utility charges if the apartment lease exceeds 1 year. B, tenants may not pay landlord's utility bill to avoid any service interruption. C, the landlord may not cause utility service to be interrupted to the tenant as a means to collect unpaid rent. Or D, if a tenant is focused to pay a landlord's water bill for the apartment, the tenant nevertheless must continue to pay rent in full. So what do you think the answer here is? No one? So the answer here is letter C, 1613C. The landlord may not cause utility service to be interrupted to the tenant as a means to collect unpaid rent. That can be considered retaliation from the landlord. That's a no-no. Landlord has to continue providing a habitable living area, including all utilities. If they're not happy with the tenant, then you can start an eviction process. So 1613 was C, is C. Very good. Number 14, leases may be terminated in legitimate ways or by other means which may be unlawful. Which of the following is perfectly legitimate cause for lease termination that does not carry a legal or financial liability? A, abandonment. B, conveyance of the property by landlord to another owner. C, death of the tenant. Or D, expiration of the lease term. So again, leases may be terminated in legitimate ways. Which of the following is perfectly legitimate cause for lease termination that does not carry legal or financial liability? No, it's not C. When somebody dies, their estate has to continue paying for the lease. The answer here is D, expiration of the lease term. So the lease expires. That's a legal, legitimate way that a lease is not considered illegal or has other financial liability. Now, if the tenant owes money, they still got to keep paying whatever they want, even after the lease expired. But leases have a start and an end date, right? Especially if they're year leases. But a lease can be what? Month to month, week to week, year to year, and they can be renewable. However, it's typically better for the landlord to create a new lease. If a lease is a year long, it must be in writing in order to stand up in court. If they're month to month, it can be verbal and it's enforceable. Now, if it goes from a year and it expires according to the lease agreement, it becomes, the leases typically say it'll become a month-to-month lease thereafter. So let's see here. What does MJ say? Agency relationship is when the tenant dies and the contract is terminated. No, you're not being represented by a realtor at that point. The relationship is with the landlord and the tenant, not the agent. Once a realtor helps a tenant and a landlord, the agency relationship ends. The relationship now is between the landlord and the tenant based on the lease agreement. There is no agency relationship. Okay, do you follow that? Because it's a lease, okay, a contract. It's a lease between landlord and the tenant, not a realtor. I wrote that wrong. Oh, yeah. Okay. So our agency relationship as a realtor ends when a property closes or a lease is rented. Okay. Then our agency relationship ends. We're no longer representing. We performed our duty and we got paid. However, we continue to keep information confidential. Very good questions. Can tell that you've been studying and you remember what you missed. That's a good thing to do is after you take an exam is to write questions that you missed so that you can go back and study those or Google them to make sure that you have the right answer. General agent. Okay, a general agent is more with a property management. If the owner gives the agent, let's say, power of attorney, or they make decisions for them. So that happens in property management. And though you're having a general agent, we are special agents because we're dealing with one owner, one property. In rentals, property management, there's multiple properties, right? So they become the general agent of the property owner. Number 15, right? When tenants default, the landlord may evict by following the correct procedures. Which of the following actions would be considered proper eviction procedures? Okay, tenants default. Landlord may evict following correct procedures. Which of the following actions would be considered proper eviction procedures? Every state has their own landlord-tenant laws. A, the landlord, with or without proper notice, can lock the tenant out of the premises. Oops. B, the tenant files a suit for possession. C, prior to filing a suit for possession, the landlord gives the tenant 14 days written notice following default where tenant does not vacate. D, armed with a writ of possession, the landlord gives notice of the demand to vacate, including removal of personal property. Sorry, MJ, it's not C. The answer to 15 is D. So the tenant defaults. Okay, so now the owner has what is called a state of sufferance, right? They're suffering because now they got to evict that tenant. That's a vocabulary. So the landlord has to follow eviction procedures. And the event, when they go and file it at a judicial court, they're smaller courts, okay? They are armed with a writ of possession. They want to take the property back. The landlord gives notice of the demand to vacate. That's an eviction notice, including removal of personal property. So when they go file the eviction, and they present that to the tenant, then they will get a writ of possession from the court, from the judicial court. And if they don't move out, then the justice of the peace comes and gives them 24 hours to move out. And if they leave their belongings behind, they have up to 30 days to get their belongings. If not, the owner can get rid of them, sell them, whatever it wants to do with them. Ooh, I put 1615S. Oh, man. Let me delete that. So it was 1615D. Okay. You answered C. It says, prior to filing a session, the landlord gives the tenant 14 days notice, written notice, following the default where tenant does not vacate. It's not prior to filing possession. First, they give them a written notice to vacate, and according to whatever the lease agreement says. Okay, they're given a notice. They might have 7 days to pay up, or whatever the particular state has on the written notice that they can post on the door. They can email, they can text it, they can mail it. Once they do that eviction notice and they post it and the tenant doesn't evict, then they go and file an eviction notice to file a suit for possession. Okay. So prior to filing a suit of possession, the landlord gives the tenant 14 days. The trigger here is 14 days of correct written notice following default where tenant does not vacate. Now, so if the tenant is in default, the first thing is they give them a notice. You've got so many days to either fix the problem or you leave. If they don't leave in that period of time, then the landlord can file a suit for eviction. 30 to 60 days notice. A lot of times, yes, it's 30 to 60 days notice. However, that's if the landlord wants to terminate the lease and rent to somebody else. Here, the tenant is in default. They don't have to wait 30 to 60 days in a default. Okay. So I would say look that up in Google for Texas law. Okay. Oh, let's see what the answer here says. So with notice, the landlord may lock out a tenant. Further, to evict a defaulting tenant, the landlord files a suit for possession, obtains a writ of possession from the justice court, and gives the tenant the required notice to vacate voluntarily. So that's after, okay, they don't vacate. So they're in default. The landlord's going to give them a notice on the door. Okay, and it again depends. So it says here, with notice, the landlord may lock out a tenant, which doesn't usually happen, but, well, I shouldn't say that, pardon me. Further, so first they give them a notice to vacate, okay, if they're in default and they don't fix their issue. So the landlord notice to vacate says, or you fix your situation, you pay, get rid of a dog, or fix this issue. And if they don't, then he further starts the eviction process of the defaulting tenant. The landlord files a suit for possession, obtains a writ of possession, okay, from the justice court. They're the smaller courts. Constructon, I have the next question. Now we're going to end at 15. Okay, so that's why the answer here was D, armed with a writ of possession. C says prior to filing a suit for possession. So yes, the landlord gives the tenant a written notice that they're in default. And if they don't vacate, then they file the, then they give them the actual eviction notice, like, okay, you're out of here. Okay, first they give them a notice, okay, you can repair the situation. If you don't repair the situation with certain days, then I'm filing an eviction. Okay, so it's one step at a time, okay? Constructive eviction, okay. Describes as which of the following? Did I type the answer for 15? Yes, okay, well, let's go ahead. Since you're already saying you know that one, let's go ahead and see number 16. Okay, and this will be the last one. A constructive eviction is best described as which of the following? A tenant self-eviction where the tenant with notice abandons the apartment due to landlord's failure to maintain habitability. B, a tenant abandons the apartment and the landlord makes the vacancy offered by filing a constructive eviction notice. C, a tenant in a dispute with the landlord withholds rent until his or her deposit is returned. Or D, a landlord forcibly evicts a defaulting tenant in lieu of a writ of possession. So number 16. Yes, the answer is A. You are correct. 16 is A, which a tenant self-eviction where the tenant with notice, so the tenant gave him notice. Okay, they gave a constructive notice, abandons the apartment due to landlord's failure to maintain habitability. So constructive eviction is a tenant-initiated vacancy action where a landlord during the term of the lease defaults on the obligation of maintaining habitability. All right. Excellent. I love this. Okay, so those of you that are watching, we were doing Texas state questions, and that was the last question for tonight. And any questions? I mean, what MJ was doing was awesome, okay? You kept participating and asking questions. And if I don't know the exact answer and I want to make sure, then I will Google it, as I was showing in some of these. Let's see here. When will you go over real estate math? I can do some of that next week. When will, wait a minute. When will you go over real estate math? You can call me Manny. Okay, Manny, sounds great. I love that. Okay, so Manny is asking for some math. I do have some math videos that I've created before. Math does not change. So I have playlists where I go over math. And however, I can prepare to do some math next week. Tomorrow, I need to prepare a little bit more to do that. So tomorrow we'll continue with more national and Texas questions. And then I'll prepare to do some math for next week, especially since you said your exam is in March. Okay, Manny, sounds good? Anyone else have question? Anyone else? Anyone else? So just for your information, you're very welcome, Manny. And so I'm an active realtor right now, and I have been since 2021. I'm a retired engineer, for those of you that may not know me. And once I gave up engineering, I became a real estate investor, but I got my license while I was an engineer because I kept getting laid off, and we sold our own company. And it was kind of a backup. I didn't necessarily want to be a realtor. I wanted to be an investor. So I learned a lot of things from my investor mentor, and a lot of seminars and trainings that I attended, a lot of studying that I did. So I'm not just a realtor. I've been an investor, buying property with no money down and selling them on owner financing, or buying them by taking over a loan from the current owner and then selling them on owner financing. I did maybe one flip, but I really didn't do any remodeling. I just bought it and then sold it a year later and made pretty good money. So I have a lot of knowledge up here that I also want to share. So after you pass your exam, you're going to say, well, what the heck do I do now? Well, I'll be creating videos on what to do next and how to grow to your business, tools to use, things not to waste your money on, and people to be careful coming after you once you pass your license, wanting you to buy this, buy that, lots of different coaching. There's a lot of coaching out there that is not very useful and they haven't done it all. So let's see here. Manny says, I'm selling mobile homes on Facebook Marketplace. It's a hard sell. Yeah, you know what? I don't, wait a minute. You're selling mobile homes as an investor. You own the mobile homes, not as a realtor, right? You're an investor because you can't represent anybody until you are an active realtor. I experienced selling on Marketplace is a real challenge. I found better use on Craigslist or other maybe Facebook pages to sell. Yes. Okay. So you are an investor. Yeah. Some people believe in Marketplace, but I got some. Yeah. I'm not real crazy. I don't have a lot of experience with Marketplace, but I tried to sell a 14-foot enclosed cargo trailer, and it was silly. I was getting real crazy remarks and people complaining. And then when I would reply, nobody was really interested. I posted it on Craigslist. Boom. Got 2 leads in a day and sold it. So I had better luck with Craigslist. Some people trust Craigslist. Some people trust Facebook. It's whatever works for you. For me, Craigslist worked better. Or when you can park it somewhere and it's visible to the public. Okay. Thank you very much for your questions. Any other questions? Yeah, Facebook is not working for me. Okay, I got it. Because there's a lot of different Facebook pages, and there are so many realtors out there that are constantly posting. And so it becomes overwhelming to people who are seeing those and posting. A lot of them post on Marketplace and then they share to all these different websites, all these different Facebook groups. I have that happen on one of my Facebook groups. And I prefer somebody posting an actual notice on the Facebook group or whatever works. Try different things. Newspaper used to work great in the past, but not a lot of people buy the newspaper nowadays. So try different things, MJ. You can go to real estate investment groups. Okay, they call them real estate investment REITs, REIT, where you can go and present your properties and get involved with other investor groups, okay, where you can sell them. Publicize them. I would say once you get if you're selling just mobile home, just the mobile home itself, yeah, that's challenging. If you were to be selling mobile homes on lots, that's a better opportunity. There's so many mobile home companies that sell mobile homes that you're competing with them. But I don't have experience with selling individual mobile homes. And as a realtor, majority of the states, I think, or at least Texas, we cannot sell mobile homes as realtors. We can sell a mobile home on a piece of land, but not just the mobile home, because the mobile home is considered personal property until it becomes what is called detitled. And that means you take the title from the mobile home with the state and it becomes part of the land. So now the land and the mobile home is like a residence and it has one property tax. Okay. So we're going to call it a night with that. I was going to say call it a day. Call it a night. And look to see you again at the next session. It'll be tomorrow. And if you all haven't, and if you enjoy my way of teaching, explaining to help you prepare, I do it differently than other YouTube channels, and you go to wherever. There's so many online. I'm one of the few that focuses on Texas and national, and that goes into detail, explaining the question and the answer and sharing also some of my experience. But you have a choice. And if you like being here, hey, I'd ask you to subscribe to my channel, click the bell so you get alert every time, and like it, write comments, okay? Let your friends know. So until next time, tomorrow should be. Thank you very much and have an awesome day. This is Wild Lily Handy Dominguez with Agent Prep coming to you from San Antonio, Texas. Good night.